Hello class, hope you're doing well. Today we're going to go over Chapter 7, Policing Legal Aspects. So far we've gone over the history and structure of police, we've looked at the organization, purpose. So today we're going to look at the legal aspects of policing. So for all of you law enforcement officers, after you graduate, this is a very important chapter for you because it's very basic information about the legality of what police do. So this chapter will go over some things that you may have thought you knew about. It may change your mind on some things as far as legal aspects, because not everything we see in movies or TV is true about how the police can operate legally. So again, make sure you read the chapter. This is just an overview. And if you have questions, you can post it on the discussion board, or you can go ahead and let me know in an email. So there are abuses of police power, obviously. The beating of Rodney King by Los Angeles Police Department. The death of George Floyd while in police custody. Those are two extreme examples of how they ignited protests and changes among the United States policing. So this was felt United States-wide, both of these issues. No one is above the law, even the police. They can be sued, they can be arrested, they can be charged, they can be convicted. So just because you're a law enforcement officer you are not immune from prosecution if you do not follow the rules and your training of what you are to do. As far as the Bill of Rights, that is what all of us have to protect citizens, and it protects us against abuse of police power. So we're going to talk about the Bill of Rights a little bit, and we're going to talk about the rights that we have and how police need to respect those rights, and if not, they can be in trouble. And also, it will encourage us to seek benefit of this law, of our Bill of Rights. So these are the amendments that are significant to this class, and they should be to you. So you should know these amendments. You should know the First Amendment, which is not here. You should know the Second Amendment, which is not here. You should also know the Fourth, Fifth, Sixth, Eighth, and 14th Amendments. You will most likely see these again. So make sure you know these. You don't now have to know exactly everything about them, but you should know something about each of those amendments. Okay? So study those. We'll talk about these as we go through this chapter. So individual rights, we have individual rights, and there's a check and balance that the government has because of the branches that we use. And again, people who feel that their rights are violated can appeal to the various courts for redress. So they can go to a court to try to get a charge or a case thrown out because their individual rights were not met. Happens all the time, and we'll talk about some of these examples coming up. As far as due process, all those amendments right there require due process, and the basic requirements for police relate to evidence and investigation or search and seizure, arrest, and interrogation. So we'll talk about some of these due process requirements and how our amendments protect us from abuses. So that is the Fourth Amendment. You should know that, especially if you're going to be going into criminal justice, no matter if it's law enforcement courts or corrections. So make sure you know that. That's kind of important, and it absolutely has to do with this chapter. Okay, the exclusionary rule basically concerns the search and seizure of a person. So basically, evidence illegally seized by police cannot be used in a trial. This case, and we're not too concerned about precedent cases, we're more concerned about the language of what the case talks about. So this case of evidence that are illegally seized by police cannot be used in a trial, that was originally only applied to federal officers back in 1914. Only federal officers, not state, not city, not county. So this was just federal officers back then, a long time ago. That was the issue back then of only federal officers, and since then it has gone across the lines to all law enforcement. So again, illegal behavior, or if we have evidence that's not seized correctly, is thrown out and the person can go free. So the fruits of the poisonous tree, basically evidence that derives from an illegal search or seizure, cannot be used at a trial. So if an officer illegally gets evidence against you, it cannot be used at trial. And a lot of times cases never even go to trial because of these issues. So again, the fruits of the poisonous tree doctrine is very important. Make sure you read about it. And again, there's different ways to get evidence, and it has to be done legally in order to protect the rights of the person that's being searched. And we'll talk more about this in a minute. Again, we're not too concerned about case law here, but when it comes to search and seizure, search is incident to arrest is limited to an area of suspect's immediate control. So if you are going to be arrested in front of a gas station bathroom, the incident, it occurred right there, so it's limited to that bathroom that's right in immediate control of that suspect. Similar to a vehicle stop, the officers now in California can only search what is in the immediate control of the driver of that vehicle. If they're the only person in the car, they can only search where the person has control. So where their arms can reach to the front seat, maybe some of the back seat, underneath the seat, but not necessarily the back seat or underneath the carpet underneath the back seat. So again, there's issues with the controlled area. And as the Fourth Amendment states, we expect privacy in our homes, even if it's not a house. It could be a trailer, could be a motor home. So again, it doesn't have to necessarily be a house or an apartment. Mapp versus Ohio, that's the ruling, that the precedent decision that applied the exclusionary rule to all states. So there's some good faith exceptions to the exclusionary rule. You need to read about those. So there is the exclusionary rule, but there's certain things that, if done in good faith by the police, can be used. So make sure you look at the good faith exceptions to the exclusionary rule. Plain view doctrine. Basically, police may seize evidence without a warrant if it is in plain view, if the officer has a right to be in that position or that area. The classic example that you'll hear again, especially if you go to law school, is a police officer walking on the street and he looks over a fence or can see something because he has a right to be in that area, and he sees maybe some marijuana plants or a methamphetamine lab, sees it in plain view, doesn't have to knock on the door, can see it from his point of view or her point of view just because they're standing there. Then you would not need a warrant to seize that evidence because it's in plain view. So look up plain view to understand what that means. That's a good example. Just police officer walking along or walking by somebody in a car, sees them using illegal drugs, boom, plain view, they can arrest them on that. No warrant needed. So emergency searches of property and emergency entry. So there's some threats that give justification for emergency warrantless action. So if a police officer, law enforcement, does not have a warrant, but they're doing a knock and talk at a door of somebody, and they sense or they feel there's a danger to someone's life, a danger of the escape of the person, or a danger of removal or destruction of evidence, then they can enter that structure on an emergency basis. That would be called an exigent circumstance. A lot of times when officers are at someone's home, they're knocking on the door, and they hear the toilet flushing or the bathtub going, they may think that could be what? maybe destruction of some evidence of some drugs. So that would be an area of an exigent circumstance where they could go in without a warrant. Again, emergency entries. Detention and arrest. Detention is different than an arrest. Make sure you read this. And again, we're going to go over this. It's pretty simple, but it's different from what you may think. So basically, an arrest occurs when a law enforcement officer restricts a person's freedom to leave. Handcuffs are not required. You do not have to have handcuffs on you to be arrested. Arrest differs from detention. When you are pulled over for a traffic citation, you are detained, even though you are restricting your freedom to leave. But it's different. Okay, the most common type of arrest follows questioning of a suspect. It may also occur when an officer comes upon a crime in progress. Many states do not permit arrest for misdemeanors unless it's committed in an officer's presence. That is correct in California, although an officer can arrest without a warrant if a felony has been committed out of their presence. So again, arrest and detention are different. Searches incident to arrest. Police have the right to conduct search of a person being arrested that's in the area of the arrestee's immediate control. We've seen that a lot on TV and in movies. And basically, the search that's done is to protect the officer. They're searching for weapons or something that can harm the officer during the transportation and booking process. So they're not necessarily looking for drugs or paraphernalia or other illegal items. They are looking for safety issues, guns, knives, sharp objects that could hurt them. So once a person's arrested, that's why the person is going to be searched. Terry versus Ohio, very famous case, set the standard for a brief stop and frisk based on reasonable suspicion. And you have to articulate, you have to describe why you have a reasonable suspicion to stop and frisk somebody. Again, not arrested, but just detained. Emergency searches, that falls under exigent circumstances, which we talked about. Depending on what the issue is, that emergency search can save lives, can prevent a criminal from escaping, and can prevent criminals from destroying evidence. Those are some of the emergency searches that can be done of persons. Now, when you have emergency searches of persons, there are some conditions that must be followed. First of all, you have to have probable cause. To think that, or to believe that evidence is concealed on the person. You have to have probable cause to believe the threat of destruction of evidence could be taking place. 3, another condition, the officer lacked time to obtain a warrant, because you have to call into a judge, present evidence, get a warrant. You can't do it in 5 minutes. You have to have a lot of information first. And then finally, the search is limited to the minimum necessary areas to eliminate the destruction of evidence. So those are some conditions of emergency searches of persons. So basically, when you get pulled over, I get pulled over for whatever, tail light out, speeding, and the law enforcement officer asks you, do you mind if I search your vehicle? What do you say? Do you have a right to say no? Of course you do. If you say no, the officer may say, okay, no problem. The officer may also say, okay, well, you know what? I'm going to have my drug-sniffing dog do a sniff outside of your car to see if there's any illegal contraband. And if that dog does hit on something that's illegal in your car, then they're going to do a search without a warrant. So basically, you need to know what's in your car if you consent to a search. If you have your buddy in your car and he's an unsavory character and may have drugs or something illegal on him or has left it in your car, you should probably say no, you do not consent. We just talked about that. Fleeing targets is an exception for a warrantless search. Roadblocks and checkpoints are legal if essential to community welfare. That's basically a drunk driving checkpoint that they do all over the place. And basically, you roll down your window. The officer's going to ask you some questions. They're going to smell your breath as you talk. and if they smell alcohol on your breath, that is going to give them probable cause to give you a DUI check. So that's a warrantless search. The vehicle can be searched at that time of whatever's in your control. Suspicionless searches, again, depending on what the circumstances are, they're very difficult to do because you have to have some sort of suspicion, reasonable cause, etc., to do a search of a person. But border searches, airport searches, other types of searches for community or national safety are done. There's no suspicion, it's just done because of safety. Informants. The book talks about informants. Basically, there's paid informants, there's non-paid informants, and there's a two-pronged test that goes with informants. And the two-pronged test is down here, that the judge must be informed of the reasons to support the conclusion that such informant is reliable and credible. Okay, this is for a paid informant. And also the judge or magistrate must be informed of some of the underlying circumstances relied on by the person providing the information. So that's a two-pronged test because a lot of times informants are not reliable. So usually when an informant is used, it will state in the documentation to the judge that the informant has provided reliable and credible information in the past to such officers. So make sure you check out informants and how they work. Police interrogation involves police behaviors that are reasonably likely to produce incriminating responses, not limited to verbal questioning. So of course, police cannot use physical abuse, coercion, psychological manipulation. Some of you that will be entering law enforcement who will be doing interrogation on suspects, you will go to some schools and have some training on this. There's a lot of different angles to use. Basically, when you are brought in, a person is brought in, and for questioning, which will be in a little bit, you have the right to not be questioned. Okay? Once you give up your right to questioning, your Miranda rights are read, then they can do anything except for these things that are on here. One thing, can police lie when they're questioning you? Can they say, yeah, your partner in the car that was with you just admitted to killing that person, and they said that you shot them? Can they lie to you? Absolutely. Police can lie during interrogation to try to get you to produce incriminating responses. So remember that. The right to a lawyer, we've talked about this before. Basically, once a person stops and says, I want a lawyer, or I'm not sure if I want to answer these questions, the questioning must stop until the attorney is present. So it's very specific. Do you understand these rights as I've read them to you? Do you request an attorney at this time? Yes or no? No. Sign this paperwork, and now we're going to start questioning you. So again, if during questioning, you've already signed your waiver, you say, you know what, I want a lawyer. Then at that time, the police have to stop and you have a lawyer. So even though the questioning has begun, you can stop it at any time. Anytime. Very important. We talked about the Miranda decision. Again, throughout the interrogation, they can exercise that. They can stop at any time. And they knowingly and intelligently waive rights and agree to answer questions or make a statement. It's a document that's signed. Different states use different documents. And usually it's going to be filmed or videotaped in an area of a booking room. Again, we talked about this. The only thing about Miranda is that this is only used when someone's being questioned about a crime. So a lot of times, what I've found is that someone is arrested for something. Police officer, law enforcement, they don't have to tell you what you're being arrested for. They find you, they suspect you of a crime, throw in the back seat, put in the back seat of a car, and on the way to jail for the booking process, the person may start talking and talking and talking and talking, and they don't stop talking. and the officer hasn't even asked them a question. So all that information, all that talking can be used against them because they've not had the Miranda warning yet. Officer hasn't asked them about a crime, but they just keep talking. And we'll talk a little bit more about this in a second, which will give you some light on how officers can get information when someone's doing this in the back of a car. We talked about the waiver. Electronic eavesdropping. Modern technology has a lot of format now for electronic eavesdropping. Basically, a warrant to unveil what a person is trying to keep in private, even in a public place, you have to get a warrant for that. Okay, but there's no legal protection from eavesdropping recording if you're in police custody, in a jail or a prison. And somebody that I know, me, learned that as a young person, as a juvenile who was placed into custody for something. And two buddies and I were in the backseat of a police car in handcuffs. And the police officer left to go talk to his buddies. And we started talking about what we were going to say. We were getting our alibis straight. So for about 5 minutes, you hear us, we're talking and we're saying, here's what we're going to do, here's what we're going to say. Of course, the officer comes back in the car and looks in and says, you guys been talking? And we're like, no, we haven't been talking. And he lifts up a little small tape recorder in the front seat, presses rewind, presses play, and there you have all of us talking. That is admitted into evidence. So that can be used against a person because the right to privacy in police custody, you do not have that right. Anyway, everything worked out with that little place into custody that I had as a juvenile, but I learned that don't talk when you're in a police car. It can be recorded and used against you. Also in a jail, also in a prison. No warrant is needed to get that information. Okay, that concludes this chapter. It's a long chapter. Make sure you read it. And again, we're not too concerned with the precedent decisions, but you should know your amendments, know your rights, and how they affect law enforcement. And as far as Rodney King and George Floyd, you may need to think about that and the differences between those cases and what happened. If there's anything else, please let me know. I'll look for anything on the discussion board, and we will talk again soon. Thank you. Have a great day.